Joanna. We are starting my talk. Congratulations to the organization of this event that I take part, several editions, and I also thank especially Professor Schweri, Professor Luiz Flávio Neto, and Professor Rodrigo Maisto, and I also thank dear Ricardo Marins Oliveira, President of IBDT, that will be the homage in the Pernambuco Forum that would happen next month, but with the pandemic aspect, it will be changed and postponed for next year. But let us say that this year we are here sharing this table, and I congratulate the talkers. It's an honor to have you here, the international representatives, Mr. Guglielmo Maisto, and also Joanna Quiller, and all the others that have published so many articles. All of them are experts in taxation, and we have also the participation of the presence of Joanna Quiller, member of IBFD, the University of Amsterdam, Alexandre Alkmin, professors of ABRADT, Guglielmo Maisto, professor of Università Cattolica de Piacenza, Leão, professor of Mackezie University. And so all of them are here, the professors that are so important persons, the CVs of the professors are being read by the chair member.
É professora da Universidade Presbiteriana Mackezie, sócia do escritório de Humberto Ávila. Esse que vos fala é o professor André Dantas, da
I am André Dantas of Recife Law University, Master by Maiden. I'm also telling you my CV.
Com sanduíche dos Estados Unidos e auditor fiscal da Receita Federal. Bom,
now, the theme that we are covering is very present in our minds. International tax law after COVID-19. Will we face a new future? Recently, we had the conclusions of BEPS project, and the international community, the researchers, they do not have the same opinion. There is no uniformity in thoughts. That's natural when it refers to scientific research. So many challenges are placed, and were placed before the pandemic. And so now we are crossing a very delicate period, and all the international companies, multinational companies that expanded, there are new markets. There is the capitalism mode that we are seeing. We have the sanitary or sewage problems, it's health problems, and we do not have answer to everything. And the consequences of it as well. So I place a question concerning taxation. Is it different in our world? We cannot answer that with the same precision, especially when we consider the world where what is right and what is wrong exists. So this is a complex multifactorial aspect that we have to consider, and the progress of these problems, they may lead us to some dubious moments. So we'll have uncertainties and securities, uncertainties. So we divide our panel to deal with this subject. We're going to see exactly the consequences in this panel of this pandemic phase. And now,
thank you, Andre. Thank you also to the organisers for inviting me to join this panel. I'm very happy to do so. And to all the participants, good morning, good afternoon, good evening, whichever suits you best. It's afternoon to me here in Amsterdam. So I will share my screen. There we go. And you should see the whole PowerPoint. Okay, so what I did when I was preparing for this panel was ask myself this question, and that is, will the COVID-19 pandemic change the fabric of the international tax order? So I'm looking for structural changes, and my aim is to see whether we're going to come out of this pandemic with a structurally different international tax system than we had before. So what has changed in the world as a result of this pandemic? Well, these are all themes that you've already heard a number of times during this Congress, and I'm sure they're familiar to all of you. So we've had some sudden swings in profitability of companies, business models have changed, government spending in most countries has skyrocketed, and we're all working at home. We're all sitting behind our computers at home, joining in this conference rather than being in the conference room, which is sort of rather a shame, but okay, that's life. So I'm going to look at each of these things and think about what they do to the international tax system as we know it. Profitability. So we've had huge ups and downs. Some profits have gone down, some profits have gone way up. The profits that have gone down, the companies that are struggling, or the businesses that are struggling, have received huge amounts of government support. And we've heard earlier in the Congress about all the different ways that that happens. There will also be an awful lot of losses being suffered. So we have questions about how to deal with those losses. Will they get effective tax relief? How to deal with all their support packages? None of those really are new structural issues. Then we've got the companies that have made a large amount of money. So, and then that gives us questions about excess profits. And we've had various calls for excess profits taxation. And I'll come back to that in a minute, because all these themes are interrelated. What else have we seen? Well, things have changed in the economy. So business models have changed. There have been some immediate changes, and that throws up a huge number of transfer pricing issues, but the next speaker, Guglielmo, is going to deal with those. Are we going to see structural changes to the world economy? Maybe. There have been calls to bring the production of vital products closer to home, for example. There have been many calls to never waste a good crisis and use the pandemic to come out of it with a much greener, more environmentally friendly economy. Those things, of course, change the underlying economy, but I don't think they change the taxation system as such, or not the structure of it. We've seen structural disparities among countries. So countries that were struggling with their budget and their economy and their social system before may be struggling more now that they have extra health issues to deal with. Again, that doesn't necessarily translate into a change in the international tax structure, although there's one issue there that I will come back to in a minute. Then we've had government spending. So governments all over the world have been spending huge amounts of money to support businesses, keeping people in employment. And then the question, who's going to pay? Because someone's going to have to pay for this in the end. Are we going to have a general tax increase? Well, eventually all of us are going to have to bear the burden. So yes, I think we're going to see, it seems inevitable, we're going to see a tax increase. But how is that increase going to be targeted? So are we going to make the millionaires pay, for example, or the rich or the very rich? And you've probably seen that over the summer, I think it was in July, an international group of millionaires published an open letter to their governments asking to be taxed more heavily permanently. But again, this is a discussion that was going on before. So we've always had discussions about the tax mix. We've always had discussions about, is it desirable, is it effective to tax the very rich more heavily? So that might be made more acute by the pandemic, but it's not caused by the pandemic. Then we've had the calls for excess profits taxes. And in the previous panel, Alison Christians was explaining her proposal, the global excess profits tax. These, again, I mean, this is not really a new pandemic issue. some of the arguments are based on the idea, well, the pandemic has caused a market failure and we need to correct that. I have to say, I find it difficult to pinpoint the market failure in many cases. And I was thinking about this and I thought, well, maybe the competition lawyers have something to say about this. And an old school friend of mine happens to be one of the leading competition lawyers in the City of London. So I phoned her up and talked to her about it and said, for example, with Zoom, do you see a market failure here? No. All she could see was the first mover's advantage. And so I think we've got to be careful with this. Is this really a market failure? Or is this just a company that happens to have the right product at the right time in the right place and therefore is able to make a lot of money? So although I can see, there are arguments, and plenty of arguments for taxing economic rent, here, if we're going to change the structure of the international tax system, maybe, but I think here there's a good case for talking to the competition lawyers first to decide exactly what we're going to do, how we're going to do it, how that plays in with competition law, how we're going to target it. And actually the friend I talked to was horrified at the idea that we would use taxation to deal with this issue because, in her words, taxation is such a blunt instrument. Cutting across all of this, of course, is the problem of international, or the issue of international solidarity. Because all governments are going to need money, but of course some countries are more able to fund that increase or fund that extra spending by raising revenue than others. And what the pandemic has shown us again, or it's just reinforced the disparities among countries in their ability to deal with issues like this. So we have a big question of international solidarity. I mean, the letter from this open letter from the millionaires, it's all very well, but it didn't address this issue. The money that they were talking about, what they seem to be talking about is paying to their own countries. I mean, they didn't have space in the letter probably to deal with this issue. But if we do go for international solidarity, so if we do, for example, have a global excess profits tax, and we find a way of increasing the revenue among countries, so not just having countries raise the revenue on the basis of what they deserve. If this crisis prompts us to move to a system where countries receive revenue on the basis of what they need, that would be a huge change. But is it likely to happen? I don't know. That's maybe rather a utopian idea. Then we have stay at home. So we're all at home now. Everyone's working at home. And that brings us a number of issues. And these have been addressed in the OECD paper that was released in April, I think. As you can see from my watch down here, I'm running out of time, so I'll have to speed up a little bit. So all sorts of issues that are raised by the problem of remote working, residence tests that are based on the presence of individuals, thresholds for taxing at source that are based on the presence of individuals. What the pandemic has done is made these issues more acute. I don't think it's caused these issues, it's made them more acute. This is a direction that we were going anyway. What this also does, of course, is raise questions about substance, because if you have remote employees, it might be much more difficult to work out exactly where the substance of a business, of a company is. And especially if that means then that the remote possibilities means that the activity of employees gets diffused across countries and it gets diffused across entities, because it's much more easy now. It's much easier now for employees from one part of the business to participate in processes in another part of the business. And one of the drivers of profit allocation cross-border is the location of individuals making decisions. And if they're spread all over the place, that becomes very, very much more difficult to resolve. But again, this is something that was happening anyway. You know, the digitalization, the remote working is maybe being given a huge push by the pandemic, but I don't think this is a new issue that has been caused by the pandemic. So if I were to conclude, I would say, yes, the pandemic is causing changes to the economy, but it's not causing direct changes to the international tax system. What it's doing, it's accelerating existing trends. So digitalization, there's a lot more digitalization and a lot more digital business going on. Remote working, I think that was going to happen anyway, and that's really been given a big push. And now we're seeing the issues that come up as a result of that. The pandemic has made some existing debates more acute. So debates about the tax mix, should we be levying wealth taxes on the very wealthy, for example? It's brought very much into focus the issue of international solidarity and how to get revenue to the states that really, really need it. But again, those were things that were already happening. So I think my conclusion is the pandemic hasn't changed the system as such. It's brought into focus a number of things that were already happening. But I have one last question, and this really is a genuine question for me, and if there's someone in the audience who can answer it, I would love to hear your response. And that's this. We have a huge network of tax treaties in the world, and they so far have almost always been negotiated face to face. Are we going to see remote negotiations, and is that going to work? And I ask that because the one thing I hear from tax treaty negotiators is how important it is to get to know the other side, how important it is to talk to people face to face. And in fact, this is something, sorry, I need to stop my phone. And okay, this is something that I also heard on the news recently in connection with the Brexit negotiations, that the travel restrictions have meant that those are very much more difficult to carry on face to face as well, and how difficult it is to carry out negotiations when you can't talk to your counterparty and see them, look at them in the eye. So question two, if we have current or past negotiators in the audience, is this going to have an effect on our network, treaty network? Is that going to mean we're going to have fewer treaties maybe? Does it mean that the difficulty of negotiation is going to mean we're going to have more standardized treaties? Or maybe what it means is that you can get the message across to your governments and that treaty negotiators are going to be some of the few people who are allowed to travel around the world. Anyway, that I think is a real question for the future. And if, as I say, if there's a treaty negotiation in the audience, I'd love to hear your response to that. And that's my input for the moment on what I think the COVID pandemic is or is not going to change in our international tax order. Thank you.
Agora vamos passar a palavra ao professor Guglielmo Maisto.
Pass the floor to Professor Guglielmo Maisto. You have the floor, Professor Guglielmo Maisto.
Good morning to everyone. Thank you for inviting me to this Congress. And what I shall do, I shall go through one very specific point regarding the pandemic emergency, namely the transfer pricing ramifications of the COVID-19. I anticipate that I shall be making comments on the other presentations during the debate, but for the time being, I shall focus on the transfer pricing impact. If we turn to the next slide, we have a list of reasons for which this topic deserves attention. And the reason are in a list, the impact of the crisis on limited risk entities, which prior to COVID-19 had no major risk function, comparability analysis during the crisis, and economic analysis. I'm referring primarily to the benchmark studies which all multinational companies do prepare when they establish their transfer price. The documentation is also an issue which does emerge in this period, and APA, Advanced Pricing Agreements, insofar as existing APAs might need to be renegotiated. If we go through all of those points, and we can move to the next slide, on the reason for reviewing the transfer pricing policy. Why should a multinational company do that? Well, I believe there are at least three main categories and reasons for that. First of all, the changes in the operations. If you look at the real world of manufacturing and distribution companies, we had supply chain disruptions, for instance, difficulty to have access to warehouses for distribution, warehouse in China, a group being placed in another jurisdiction and having difficulties to have access to the warehouse for distribution. That is certainly a big change, which we have experienced during the period. A shift in production capacity. It was not uncommon that during the most difficult part of COVID-19, several companies have changed their manufacturing operations in the textile business, for instance, and they started to manufacture masks for the emergency or sanitary devices just to basically cope with emergency and also reduce in a way fixed costs. That also is something which could not be expected. Or extraordinary costs which have been incurred, such as the cost to prevent the virus to basically expand and comply with the domestic regulations also in factories, offices, and so on. These are extraordinary costs which have been incurred. Also, in terms of people, we had changes, especially in functionality. Many people and managers in low-risk companies had to take extraordinary and very important decisions. For instance, renegotiation of a lease agreement with a landlord, which is a decision which could carry significant economic effects. And that was something which, in combination with the legal aspect, came into play precisely during the pandemic event. Many of us are aware of the operation of certain contractual provision, such as termination or renegotiation of contracts, which was required. If we move to the next slide, we have another element which comes into play in the review of the transfer pricing policies, and that is the question on whether or not limited risk entities should be affected. When an entity is guaranteed a remuneration, take a distributor who is guaranteed a cost plus margin. Does the pandemic event justify a change of the profitability of a limited risk distributor? Many tax authorities might say if there is a risk of a pandemic event, that risk should be borne by the entrepreneur and not by the limited risk. But the problem which does arise is the one relating to the dichotomy between limited risk and no risk. And the OECD guidelines themselves make a reference to the fact that also limited risk, a low risk function, situation which exists, for instance, in a limited risk distributor, does not mean that a loss-making transaction can never be made. It can never be taken into account. That is a quite important point which shall have to be addressed by tax authorities. If we look at the next slide, comparability analysis during the crisis, there is a need to look at comparability, to compare the contractual terms of a transaction, if the contract concluded by the related parties included a force majeure provision, the effect of governing law, functions performed, assets used, and risk assumed. That is also something which will need to be taken into account. And if we turn to the next slide, we have the economic analysis. Namely, the point is that many companies belonging to multinational groups are aware that when the benchmark analysis of comparables shall be available for 2020, namely the profitability of independent companies operating in the same business, the results of the 2020 should be lower compared to the results of prior years. So they know already that the profitability that they guaranteed within the group in prior years shall not be in existence for 2020, but the data are not yet available. So there is a need basically to cope with the situation in which I am aware that the profitability is lower because the benchmark analysis of the comparables in later years shall document that the 2020 shall present a downturn also for third parties. And indeed, that is one of the reasons for which many taxpayers are reviewing their transfer pricing policy in advance. If we go to the next slide, we have the need to justify a change in the TP policy for 2020 because of the pandemic event. And you can see on the slide at the very end, some tax authorities have already taken a position. The IRS in the US, in terms of transfer pricing and best practice on TP documentation, they acknowledge that a proper documentation which may document the negative and adverse results in 2020 might justify a distributor to fall outside the interquartile range of comparable companies' profitability. So there is already an acknowledgement in the position of a certain tax authorities that a well-documented change in reduction of profitability may be justified if the reasons for the downturn are well documented. The last point I wish to address, and we can turn to the last slide, we are aware of the large number of APAs which have been concluded in many countries, bilateral APAs, multilateral APAs, agreements which have been reached between multinationals and tax authorities. And many of these agreements, on the basis also of the OECD guidelines, provide for a possibility of revising or terminating the agreements when there is a significant change in the business operations, or when economic circumstances which were unforeseeable at the time of the conclusion of APA suddenly occur. And that is one of the issues that many tax authorities are facing. Some tax authorities are taking the lead and asking taxpayers who have concluded APAs to declare and to inform the relevant tax authorities on whether such conditions, such revisions or termination are there in order to basically start renegotiating the agreements. Some other countries are waiting for a position by the OECD. The OECD, as Joanna Wheeler indicated, has already partially, in a very soft way, taken a position on certain issues regarding the application of the tax treaties in the pandemic environment. And we understand the OECD is working also on the transfer pricing ramifications of COVID-19, and many tax authorities are waiting for the results of the work of the OECD by year end. That is basically my presentation on the transfer pricing of COVID-19, and I should be pleased to carry on with some comments during part 2 of our panel. Thank you.
Thank you, Professor.
Thank you, Professor. Well, before starting the second part of our panel, we will have Chris, Marta, quiz, Q&A. Thank you very much. Good evening. We're waiting the team to place the quiz so you can answer. 2 interesting questions. Will the COVID-19 pandemic change the fabric of the international tax order? A pandemic, second question, will the economic crisis resulting from COVID-19 pandemic increase the search for ways to save taxes? So you can answer, and following with our panel, the second part will deal with the consequences of the pandemic on the digital economy and tax orders. So the first lecture, Professor Vikram.
Thank you, Andrea, for that
Obrigado, Andrea.
introduction. And thank you, Professor Maisto and Professor Wheeler, for your insightful comments on transfer pricing and tax treaties. Keeping aside the transfer pricing and tax treaty debate, what I'm going to speak to you about today is about the consequences of COVID-19 on the OECD digital project. Now, just to give you a little background for Pillar 1 and Pillar 2, is that before I get into the discussion, we've seen that COVID-19 has actually shown that many businesses can flourish in the times of a pandemic. So we've had many automated digital service kind of businesses like the big Facebook, Netflix, Apple, so on and so forth, big digital companies who made a lot of profits. At the same time, you've had a lot of consumer-facing businesses, such as pharmaceutical companies, fast-moving consumer good companies, which are selling food and ice cream. They've also somehow improved their bottom line position as a result of the COVID-19 crisis. So some businesses, which are actually digital as well as consumer-facing businesses, they have flourished in the Corona times. At the same time, what the COVID-19 crisis has shown us that because of all the packages that were given out by the governments of almost all countries are handing out packages to counter the coronavirus. The government needs money to fund these packages, these measures. So the government needs to raise revenues. That's the bottom line. So the COVID-19 crisis has shown that governments need to raise revenues. Now, these revenues can be raised on a unilateral basis, on a bilateral basis, or a multilateral basis. Now, what is the approach that is currently being considered? So at the OECD level, Pillar 1 and Pillar 2 of the digital economy debate wants a multilateral solution in place, both for Pillar 1 implementation and both for Pillar 2 implementation. They want some kind of multilateral consensus around these two pillars. Whereas on the other hand, the UN favors bilateralism, and this you can see in the new article that was proposed by the UN with respect to fees for digital services or fees for automated digital services. That solution, in my opinion, is a very basic solution. It's like a kindergarten solution, so I wouldn't really spend too much time on that. But at the same time, we've seen that some other countries want to follow the unilateral path. So you've had many common law countries, UK and Australia, introducing diverted profit taxes, and at the same time, many European countries preferring for the DSTs, India equalization levy, so on and so forth. The EU currently, it favors a multilateral solution, but at the same time, it's saying if there's no multilateralism in place, we will introduce digital service taxes. And the recent proposal from the French Finance Ministry also supports the creation of a digital service tax. So you have these different policy-making organizations, the OECD, UN, and EU, and they have different perspective and, of course, different countries with respect to digitalization. But the bottom line is all these measures want to raise revenues. Now, let's move into the Pillar 1 debate, because I see there's a lot of confusion around Pillar 1. So I just want to explain how Pillar 1 works with a very simple example. And because Pillar 1 allocates more taxing rights to market countries, I will use Brazil as an example as a market country, because this conference is organized by the Brazilian organizers, so I'll use Brazil as a market country. Now, just take a very common business model. Common business model would be, let's say, a US parent, which would set up a principal or a centralized business model, either operating from Switzerland, like a principal company. The principal can be in Switzerland, Luxembourg, Netherlands, Ireland, Singapore, Hong Kong. It can be in all these small and mid-sized entities, or the US parent could be selling directly into the Brazilian market. So let's just assume that in this example, the US parent sets up a principal company in Switzerland, and it licenses all its trade intangibles, marketing related intangibles to the Swiss company to sell outside the US. And in return, the principal company pays a royalty to the US parent. Common business model. Now let's assume in the first situation, there is remote sales that are being made in Brazil. So without this multinational group having any physical presence as such in Brazil. So remote sales are being made here. In the second situation, let's just assume that the multinational, the principal company, is selling its products, or mostly its products, or maybe its services, to a low-risk distributor entity in Brazil, and the Brazilian entity is then selling those goods to the clients. In the third situation, let's just assume that the principal has set up a full-fledged distribution entity in Brazil. So it has extreme amount of operations which are being set up in Brazil, and it's making sales through these full-fledged entrepreneurial operations. Now, with respect to Pillar 1, now what does Pillar 1 aim? Now, if you take these three different situations, in the first situation, because remote sales are being made into Brazil, Brazil would be entitled to an amount A allocation. That is the amount A which will be determined on the basis of a M&E group approach, because if you look at the current framework, tax treaty rules, transfer pricing rules, they are rooted to the separate entity philosophy. But amount A of the OECD's digital project reallocates profits to market countries based on M&E group profits, multinational group profits. So amount A would actually be allocated to Brazil in this example, in the first situation. Now, in the second situation, when the multinational is selling into Brazil through a limited risk distributor, Brazil would be allocated something known as amount B. Now, what is amount B? Amount B is just like a fixed margin, which is going to be based on the ALP. You see many multinationals, they operate with limited risk distributors. These limited risk distributors are usually compensated on the basis of 3% on sales, 2% on sales, 5% on sales, based on the industry in which they operate. So this is going to be a fixed margin based on the ALP that will be allocated to Brazil. And somehow, Brazil already has special rules on transfer pricing. So amount B stays within the existing transfer pricing framework. And probably, I think it's also in line with Brazil's entry into the OECD, in the sense that the Brazilian transfer pricing rules are currently being rediscussed, and probably this kind of fixed remuneration based on the ALP is also in line with the Brazilian transfer pricing rules. But at the same time, in addition to an amount B allocation, which could be 3 or 4% on sales, Brazil will also be getting an amount A allocation, which is built on the residual profits of the multinational enterprise. Now, if in the third situation, when the multinational is operating in Brazil through full-fledged operations, that is where probably there's going to be an overlap between the profits actually being reported by the full-fledged distributor in Brazil, which is known as amount C of the OECD digital plan on Pillar 1, and amount A. So because in both situations, residual profits are being booked in Brazil in the third situation. So in this kind of situation, there could be a situation of double counting. But I would like to say at this stage that if the full-fledged distributor is operating in a loss situation, then definitely there's going to be an amount A allocation to Brazil. Now, if Brazil as the market country in the three situations is going to exercise its taxing rights, some entities within the multinational have to provide relief from double taxation, either through the exemption method or through the credit method. And this is going to be the principle, because that's the first point of contact with respect to the sales. Now, if the profits of the principal are low, or it's a loss-making principal, then probably because the principal pays a royalty to the parent is going to provide relief from double taxation. Now, what does this show? Now, this shows that actually some revenue is going to be allocated to developing countries like Brazil, or market countries like Brazil, and probably the amount which are going to be allocated to these market countries is going to be much higher than any allocation that will be made under a unilateral measure, which only targets a narrow set of businesses, because all the unilateral measures that are being contemplated right now, they are applicable only to a selected number of automated digital businesses. But amount A, Pillar 1 of the OECD project, is broad. It applies to automated businesses, consumer-facing businesses. So probably market countries are benefiting from the Pillar 1 proposal, contrary to what has been said in other panels or other discussions that it's not really good for market countries. Well, it all depends on the reallocation percentages that are going to be discussed in the amount A allocation. Now, with respect to Pillar 2, I've been hearing that Pillar 2 is bad also for developing countries. But here, once again, I just want to show you how these rules actually are going to work. Very simple example. We have a German parent which has an intermediary entity in between, and that this entity is a genuine operating entity. It's carrying out value creation activities, full-fledged activities, but it is a zero tax subsidiary. So let's assume it's an IP box in the intermediary location, and this IP box is licensing its IP to a Brazilian entity, and the Brazilian entity is paying royalties of $100 on this income. So how do the Pillar 2 rules work? Now, the Pillar 2 rules actually have different mechanisms. There is one set of rules which are known as the income inclusion rule, and the second, which is also linked to the income inclusion rule, is the undertax payment rule. The top-up rate for that rule is going to be agreed at 12.5%. For example, that's the current rate that is being floated around. Whereas on the other hand, there's another rule which is known as a subject to tax rule. And actually, this rule is in favor of developing countries or source countries. Let me not use the word source or market. Let's just say source countries where the payment is actually being made from. So how would this rule work? So on this 100 of payment that has been made from Brazil to the intermediary location, contrary to what everyone is saying, that this proposal favors residence-based taxation, the subject to tax rule would apply first as per the leaked document, which has been the pillar 2 document, which has been leaked. So on this payment of 100, Brazil would have a first right to tax this income. Well, the minimum tax rate under the subject tax rule and the minimum tax rate under the income inclusion rule, they're different. So here, Brazil would apply, if it signs up to pillar 2, they would tax $7.5. On the other hand, if Brazil as a market country exercises taxing rights under the subject to tax rule, which is a rule linked to tax treaties, Germany would apply the income inclusion rule. But under income inclusion rule would apply this income of 100, which is not taxed in the intermediary location. Germany would tax it at 12.5%, the top up to the top up rate, but it will provide a relief for the taxes that have been paid under the subject to tax rule. So effectively, the tax that will be paid in Germany is going to be $5. Now, what happens if Germany, for instance, does not want to apply its income inclusion rule? Or it could be a German parent, or for example, it could be an Indian parent, Chinese parent. And what happens if the state of residence does not want to apply its income inclusion rule? Then the country of source, once again, under the undertax payment rule, would apply and would tax the $5, which would be allocated, which would have been allocated to the parent, but now it will be reallocated back to the source. So in effect, if the income inclusion rule would not apply at the German level, then Brazil would be taxing around $12.5 of this income. So in one way, if you look at the priority of these rules, the way they are applying, if the subject to tax rule is comes into effect, it's a rule which is actually beneficial for source countries, the way the pillar is being designed right now. And this could actually allocate more revenue to market countries and developing economies, not only like Brazil, but also to India, China, so on and so forth. So contrary to what has been said about the OECD being really bad, or the pillar of digital projects are against developing countries, market countries, with these two examples, we can see that there is going to be more revenues that market countries or developing countries could actually raise. Just to sum up, I know I've already exceeded my time. I'm sorry for that. Just to sum up, I would just like to say one thing on pillar 1. Now, if market countries just go over the board and they start arguing for higher income reallocation percentages to the market country, then what OECD members are going to say is that, okay, if we reallocate back excess amount of corporate income taxes to market countries, then OECD member countries, I'm sure that's going to be in the future, what they're going to do is they're going to argue for origin-based consumption taxes. Because under the current framework, when a company in Brazil sells something in India, India collects VAT, Brazil collects corporate income tax. But you want to shift the balance and you want to say, okay, India should pay more, India should get more corporate income tax, then Brazil should argue logically for more VAT allocation. So you would see developed countries arguing for more origin-based taxes, consumption taxes. Now, clearly to implement these proposals, Pillar 1 and Pillar 2, a multilateral framework will have to be developed. And this framework is absolutely necessary to avoid compatibility issues with tax treaties as well as EU tax law. So multilateralism is the key. Now, contrary to what has been said before, as well as on other forums, unilateralism is the worst way countries can actually go forward. Unilateralism is just going to create problems time and forth. It's well documented literature. I don't need to repeat all the arguments. Unilateralism is not what we should focus on. The focus should be on a multilateral solution at the OECD level. And if you think about it, the OECD is not really silly. Huh? They don't think that they're a silly organization. They don't know about the market country perspective. Then that they don't know about the developing economies perspective. And the way the proposals have been designed, it looks into the entire system as a whole. It also looks into income tax, corporate income tax, consumption taxes.
Yeah.
So
conclusions. Your conclusions. Time.
Yeah, sorry. And just to finish it off, the proposal should be the proposal, the way they stand, at least in my opinion, they look balanced for both OECD and non-OECD countries, given the fact that here we are trying to tax corporate income tax, not consumption taxes. Thank you for that. And I'm sorry that I exceeded my time, but I'm very passionate about this topic.
You are welcome. Agora vamos convidar.
Now we invite Professor Alexandre Alkmin for his lecture. 12 minutes, Alexandre.
Good morning, everyone. Good afternoon to the colleagues that are in Europe. I will try to save and use my time. But first of all, I want to congratulate ABRADT for this magnificent forum and the persons of like Ricardo Marim, Luiz Schweire. I thank everybody, Luiz Neto as well for the invitation, Professor Martin and André for the organizer of this perfect panel. And I am the person chosen for talking about a problem that is and existed before or was studied before, as Mr. Guglielmo Maisto has said. We did not discover any problem. We capitalized the problem that we already have, demanding more urgent solutions, requiring a certain movement and understanding of these new problems that the digital economy brings to the world and that I optimize and push to our daily affairs with the COVID-19. Specifically, I will focus on the use of this fiscal, the tax havens. And just to put in the context, facing the tax haven and that tax haven competition since that time, the national society and the international organizations are used to the effects and try to restrain them because it affects the collection from the part of the normal states. And there are other effects that the not correct use of the tax haven, which are used and which are studied by the international community. So we have to consider three aspects that are very important. First, the financial centers, the tax haven, sorry, it provides payment mechanisms, mobility, financial mobility, which are quicker, less bureaucratic, and an increased recipients of the financial transactions of a same group, multi-localization group. If you consider that a normal transaction in Brazil may take 5 days, and demanding bureaucracy like filling forms, certification of the operation, etc. In a tax haven, we have this transaction in one day. For the next day, it's there. So tax haven and concerning tax planning, there is less tax to pay in a group of companies, mainly due to facts like technology companies that service rendering, organized companies in tax haven, and companies, financial companies for loans in the same group, and also intermediating sales and buys, and also the holding companies in the planning of the taxation. So tax havens are always used and have always been used for money laundering and equity disposal. So at that case, a tax haven, those that have their equity there, it's always a challenge to be faced by the countries with normal taxation. But tax haven is changing, mainly after the events of September 11th. And also the crisis in 2008, they represent restrictions, the use of the tax havens, especially when it concerns to opacity, lack of transparency that has always characterized the tax havens. And they were obliged, they had to finish the excessive accounts, and where you have and also recently a series of instruments that are pushing more and more the functionality, the traditional functionality, and used for planning and in terms of taxation. The number of accounts simply finished. And we identified a very aggressive position from the part of BEPS in G20 of OECD to restrict the effects of the operations by companies localized in tax haven, where used to have numbered accounts and they do not exist anymore. So in this case, the development, the improvement, maintenance, and exploration of intellectual property, so attributing who is the right owner of that intellectual right, looking for the substance of that entity, looking for the substance of that company. Another concept that is gaining more importance, mainly when it refers to reviews of the treaties uh, after the review of the model in 2017 by OECD, is the concept of beneficial ownership. Who is the effective and real beneficial ownership with? So in tax havens, it identifies that if it's not the correct person, we put aside the intermediation of that negotiation using the tax haven, mainly when it comes to the multilateral convention of inter-exchange of tax matters celebrated by over 147 countries that is already in force since 2018. See that Brazil, we do inter-exchange of information, financial information via the report with 147 signatures in the convention, and we've done inter-exchange of information via the report, OEDC country by country report with all the members of this multilateral convention. Brazil, in this case, has a very special peculiarity. Brazilian revenue is able to process this data and look for and consider taxation based on that information. In this context that we have coronavirus placed in, that's COVID-19, bringing a new reality to people and to companies. Now we work in home office. We buy by digital means in physical stores or marketplace, but what calls our attention is the digital services and the games. We can say that eventually games, they're not important, they're not related or relevant, but imagine that in 2019, this sector with digital games, the turnover was $152 billion. How do we tax it and who taxes and when? So if you consider it, it's possible that these operations, digital operations, are always processed via the blockchain. Imagine in the blockchain, there are innumerable assets that are cryptographed, that we call crypto assets or bitcoins. It's very common crypto coins are very common, mainly in the post-COVID-19 situation, identifying operations of acquiring assets and rights and services via payments done in this blockchain environment. There is in the functionality of the blockchain something that's very interesting. The states per se identify the presence of an eventual crypt asset in the moment that the person, the real world, acquire its currency, its asset via the exchanges. And the operations that are done among electronic currencies in the blockchain, they are not accessible by the states because this information, virtually open, do not give safety concerning who are the owners of the assets. That's why, and because of this, that the big companies of the technology companies are looking for a way of having their own crypto coins so they can do acquiring transactions, benefits, services in that universe of crypto coin, uh, electronic way with and the benefits and the activities, operational activities are not reached by the tax activities. So we identify and call it digital tax havens. And as they are used exactly with the same functionalities that in the past they were used by the countries in general. They are used as centers, financial centers. And so if an operation, financial operation via a tax haven takes 1 day, using the blockchain, acquiring and sending resources to another country, it can do in not more than 3 minutes. I've watched that a person transformed reals in yen in China in exactly 3 minutes. And for planning purposes, tax planning purpose, there is the destruction of a concept all destroyed concerning source and residence when it refers to operations in the blockchain. We don't know exactly who is the resident. We do not know what's the source because we have no idea. And the operations of buying and selling with the coin itself using the blockchain system. So opacity of the blockchain leads to the possibility of money laundering to an extent that's comparable when we had the numbered accounts in the past and anonymous societies. And so what do we do? In this context, that's the biggest question, interrogation mark presently. We have the increase of the use of this system. Imagine that a Bitcoin in January 2017, it referred to $129 and now it's $10,986. So you see the growth of this system. So, of course, it's an investment, and we do not have an answer to these questions. The studies that go forward, more advanced ones, they are in the digital subject committees in OECD, and there is another one in the European Parliament looking for solutions that do not have an answer. I thank you for the opportunity to take part in this event and my service for any participation and answer. Congratulations, Alexandre. I think that the organization will show the result of the quiz. Please. On the screen, 49% yes, 51% no to the first question, 90% yes. For the second question, 7 to the second. Okay, now carrying on with our panel, we will now have Immediately, I invite Dr. Marta Leão because we're starting the debates. Marta Leão, please, your comments. Thank you, Professor André. Good morning, good afternoon to everyone, depending where you are. It's very interesting, the result of the first quiz, because we see there is a technical match here. So the doubt that people have, pandemic will change definitely the world in terms of the international taxation or not. In this context, we had question Michel Nestramo. I would like to present it to you, all the panelists. It's very interesting. If pandemic status will be crucial to the changes that we will have, probable changes, internationally speaking, or will it be an argument, political argument only, used by the states to give some speed up process to the proposals that are already being placed, to change that are already happening, that wouldn't be implemented so quickly in another circumstance. Of course, it goes very well with the presentation of Mrs. Joanna that wrote an article, a book. We have to read that. You must read that. She deals with these questions in this article and in this paper. Will we have this increased solidarity among the countries, or on the other hand, we may have a struggling that is a fight that will be bigger due to the necessity to increase that we've seen that we have more public expenses. It's not only an economic crisis, it's also a crisis in the health, etc. So for that, I'll pass the floor to Professor Maisto because he would like to comment Professor Wheeler's. So Professor Wheeler will come after Professor Maisto because they have questions among themselves. Professor Maisto first taking the floor.
Thank you.
5 minutes.
Thank you, Marta. And,
Muito obrigada, Marta.
Can you
Obrigado,
hear me
Marta.
well?
Está me ouvindo bem? Mais ou menos.
So,
Assim, meus comentários quanto ao futuro da tributação depois da pandemia e sua emergência. Eu tenho 3 comentários, basicamente. Primeiramente, sim, eu acredito que nós teríamos mudanças relacionadas à maneira com que conduziríamos as coisas depois do trabalho remoto, mas eu não acho que vai ser uma mudança muito grande, especialmente entre fronteiras. Haverá um aumento de trabalho remoto, mas se você observar as ramificações na base internacional, eu não acho que será uma mudança muito grande comparando com a situação que nós já temos agora. O segundo aspecto, sobre a solidariedade. Eu acho que a Joanna mencionou solidariedade, mas eu não acho que solidariedade possa dizer, de repente, surgir por causa do evento pandêmico. Sabemos que na Europa, na União Europeia, nós temos emergências relativas a países imigrantes, aos emigrantes. E, então, se você observar o problema que nós estamos experimentando com os imigrantes e com o fundo de recuperação, existe muita discussão entre os países sobre esse assunto, sobre o que nós chamamos de solidariedade. Então, seria um pensamento que a gente tem que pode não ser a realidade. Digamos, porque afeta o bolso de cada um. Então, quadro que nós temos que ver com relação aos países e que eles teriam que usar depois da crise pandêmica, quanto aos aspectos técnicos, seriam, por exemplo, grandes mudanças que são feitas nos negócios durante a pandemia são por emergências. Nós temos, então, por exemplo, perdas com relação às medidas que temos que tomar, perdas introduzidas, as possibilidades para as companhias, não só seguir e carregar isso para frente, as perdas, e também para introduzir durante a situação de emergência como lidar com essas perdas durante a crise internacional, os prós e as medidas que têm que ser reintroduzidas para recuperar essas perdas. Então, no caso, alguns países poderão talvez manter no futuro essa situação. E, finalmente, quanto ao excesso de lucro, em alguns países já introduziram no passado o que você chama de tributo em lucro excessivo, como foi colocado. E agora nós enfrentamos problemas constitucionais, porque você tributando diferentes negócios é possível, mas você precisa achar um argumento sólido para poder evitar violação do princípio de qualidade ou violação do princípio de habilidade de pagar, capacidade de pagar, igualdade, princípio de igualdade. Alguém que nós teremos que enfrentar e pode ser algumas dificuldades. As minhas conclusões baseadas, nós estamos enfrentando um desafio que outros palestrantes já falaram também, do que talvez possam bem mudar a tributação internacional, a verificação quanto à Covid-19, ramificações mudaram as regras. Eu não acho que é muito significativo. Se vocês me perguntarem qual seria a área que precisaria ser olhada com mais cuidado no futuro, eu diria que seria a resolução de litígios, porque nos muitos países nós temos que incluir também o Brasil e a Itália e muitos outros. As resoluções de litígios, ela necessita clareza contra a tributação internacional, e o mecanismo dela pode ajudar bastante. Na Europa, nós temos passamos, então, uma diretiva sobre a arbitragem, e talvez seja o futuro também nos anos a vir. Muito obrigada. Obrigado, professor. A Joanna Miller, taking the floor. Muito obrigada. Eu acho que você concorda.
Some of the points you've raised, you said international solidarity is not likely to happen. Well, this is my point exactly. I don't think it is. What the pandemic has done has highlighted the differences between countries. My point there is that if what comes out of this is international solidarity in the sense of some mechanism that enables needy countries to obtain some of the international tax revenue as of right, then we've had a fundamental change in the international tax order. But I don't think that's going to happen. So I think we agree on that one. The excess profits issue, yes. I mean, I also agree with you that this needs very careful consideration. And in that respect, I think it would be useful to go and talk to the competition lawyers, because they're the people who've been thinking about market failure and what might be excess profits for a long time. So I think there might be a very fruitful conversation to be had there. Answering the questions about the pandemic, this was a question that came up in the chat a while ago. And the question was, is the pandemic the key to further changes, or is it a political argument to speed up pending proposals? I don't think it's going to be an argument to speed up pending proposals. It might be a key to push certain proposals like environmental taxes, because of all these calls to come out of the crisis in a better way. So there are plenty of calls to do that, people who want to, use the crisis to move to a greener economy, and taxation might be part of that package that states use to try and push us in that direction. Is it the key to further changes? I think what's happening is, as I say, it's not that the pandemic is causing changes, but of itself, but it's accelerating trends. And one of those trends, something I didn't have time to talk about earlier very much, is the remote working. And I think that's something that was going to happen anyway, but the pandemic has pushed it very much, pushed it forward very fast. And if you look at the response of the OECD, which is now saying in the paper about the interpretation of treaties, well, yes, they know that, just absolutely counting days is not entirely what we meant. You have to look at the intent, and they're bringing in the intent into the equation. And you look at what's going on with the pandemic, with remote working, and the issues that's going to raise, and whether, you might have source state taxation issues because of people being stuck in states and things like that. That whole debate, what that brings up to me actually is just the general questioning of the importance of physical presence. So for a long time, the location of individuals, their physical presence, has been an important part of the international tax system for residence purposes and for source state thresholds. And the reaction to the pandemic, where people are then being forced to be in places they didn't plan to be, or to work in places they didn't plan to work, and the debate that's brought up brings into question the reliance on physical presence. And I think what that does is accelerate the debate, which was already there. I mean, there've already been articles and debates about it. It accelerates the debate as to, wait a minute, how important should physical presence actually be? So the pandemic hasn't caused that issue, but it does throw the debate into relief, and it sort of accelerates the issues that we've got to deal with. That's the point I'm making. Thank you.
Thank you, Joanna. Professor Vikram, agora eu vou passar a palavra para você tecer seus comentários.
Professors, please, your comments, and please, can you do that in 3 minutes, because we don't have much time. Professor.
Surely, thank you for that, for giving the floor back to me. I know I exceeded my time, so I will not take too much time here. I'll keep my comments to a minimum. Well, I agree with what Professor Maisto, Professor Wheeler have already mentioned, as well as Mr. Alkmin, who's given a very nice presentation. Coming back to the comments of Professor Maisto and Professor Wheeler, now you see, what I see is that, international tax law is currently rooted on the separate entity principle. So like I mentioned to you before, tax treaties and transfer pricing rules apply at a separate entity level within a multinational group. They treat each and every entity on a separate basis. Within the separate entity principle, I think one of the big areas where a lot of improvement needs to be done is not really in the tax treaty area, but mostly in the transfer pricing area, to build more certainty around transfer pricing and the application of the arm's length principle. Because right now, the way the post-BEPS arm's length principle applies is that for me, it's just a negotiation tool between taxpayers and tax administrations to come to some kind of agreement. So the arm's length principle is quite complicated, and we need to do something around that to make it work effectively. And Professor Maisto touched upon that very nicely. He said dispute prevention and resolution, that's the key. Then I think that's really the way forward within the separate entity principle, dispute prevention and resolution. But at the same time, I see that international tax law will evolve, especially with respect to taxing multinational groups. It will move away from the separate entity approach and move more towards a M&E group approach. The M&E group approach could be in the form of a Pillar 1 solution or a Pillar 2 solution at the OECD level, or the EU which is again back on the table within the EU with respect to reallocation of multinational profits, or probably some other kind of solution. But I do think that we are going to live a very interesting time in the future, If we have, we'll be exposed to a separate entity approach and an M&E group approach, and both of them are going to apply parallelly on various matters. Probably 100 years down the line, because we spoke about 1920s, now we are in 2020s. 2020 is where we are seeing movement to the M&E group approach. Probably in 100 years down the line, we will completely get rid of the separate entity approach and move directly to the M&E group approach. So that could happen 100 years down the line. I don't know. This is just a guess for the future. The floor is back to you, Martha.
Thank you, Vikram.
Thank you, Vikram. I would like now pass the floor for Professor Alexandre, and I ask, it's very interesting for those abroad foreign professors to bring this to the Brazilian Congress. Michel's question, is it applied because we live in Brazil and it's strong on bills, but also decisions by the STF or Supreme Court to identify and justify some effects? Well, within the international context, I agree with those who spoke before me. Just to notice, I believe if we did not have a consensus of several of the points that were debated, this consensus is more and more difficult when we have financial crisis that we're experiencing, and it's a strong when we experience this. In addition, and simultaneously, we have noticed a movement of a certain unilitarism, especially regarding USA, with several policies and measures, including tax matters adopted by the government, that makes this sense a bit more difficult to reach an agreement for the development of those topics already debated. But following the line, what you mentioned, Martha, here in Brazil is interesting because we have identified recently a number of rulings on the STF regarding tax matter with no precedent, so no case law, according to constitutional courts. The issues pending for 5, 10 years now are being judged because they are virtual, without the presence of counselors, press, and factor pressures, and decisions are being placed virtually by the ministers of the Supreme Court without the wide debate over the legal community about positions being adopted. Equally, we have several debates on the legislative branch, and they want to also amend the constitution, the tax code, and it's being restricted by the society. But in fact, those of us who follow the legislative work, we almost don't sleep because at any moment there's a session and the reporter talking about the constitution, the bill is placed to vote, it's voted, and there's no one, it's not an ordinary procedure with debates and wide attendance and participation of society, because this was the rule before everything being virtual. So we have seen an opportunity politically wise to solve and decide tax issues in spite of not having society participating. Well, thank you very much, Alexandre, especially for keeping on time, answering the question made. Professor Maisto asked the floors. So 2 minutes, Professor Maisto, for your final remarks, and then André will take the floor. Maisto, Professor, you have the floor.
For giving the time. I just wanted to go back to one point regarding how countries may interpret COVID-19 differently. Reference was made, for instance, to the guidance the OECD gave on physical presence in a country because of a lockdown, with some sort of mitigation, which was recommended by the OECD, saying that because of the special circumstances, then physical presence and resident by reason of a lockdown might be taken away. It may be interesting that Spain adopted a ruling, published a ruling in 17 June 2020, taking precisely the opposite direction. A couple of Lebanese individuals were stopped in Spain and they could not expatriate because of COVID-19. And the tax authorities took the position that the days spent in Spain had to be considered for the purpose of tax residence, regardless of the emergency, at least when the legislative restriction for moving outside Spain were lifted, which happened early June. Then there was no longer any reason for lifting the number of days spent. So in a nutshell, you can see already that countries are taking different positions. I know Australia and the UK have taken a different view. So that's why I think arbitration is going to be very helpful in the future. Thank you.
Obrigada, professor. Eu queria, antes de passar a palavra...
Thank you, Professor. Before passing the floor to André, thanking the coordination, congratulated for the organization of this event. We would have a lot to address. These points are truly polemic, and regarding the quiz mirrored this. I would like you to read the papers of the Congress. The panelists presented text on these points that can be subject matter of future debates, and for sure debates don't end here. It's just a starting point, and we will for sure go beyond these topics on the future. Thank you very much for the invitation. I pass the floor to Professor André Dantas. Final remarks. Thank you all the members of this panel. Fantastic lectures, and it's calls, I would like to call attention for one detail. It's a very difficult moment of pandemic, but the international context on taxation was never an easy thing. So what was set for the opening or BEPS project coordinated by the OECD, it's decisions that are mistaken made in the past by developed countries that opened their sovereignty regarding tax, and with the radical drop on collection, this true is shown on a crisis, economic crisis that we had in the past, and this crisis is even more difficult in the moment now that we experience with international pandemic, with outcomes difficult and heavy to be carried by and borne by the humanity. We could be more human and solidary in our approach. What we have noticed is an uncertainty moment where we don't know it will prevail social international solidarity, or if this tax war will be cutthroat. The next times will show you what time of convergence we will have, if we will be truly more human and solidary, and then we can organize a true friendship amongst people, or developing countries will keep on more developing countries and fighting to hold their tax burden. So thank you very much, this Congress, those who organized, for the invitation to be here. And I'm so pleased of being the president. This table. I was happy when Professor Guglielmo Maisto was part of this. Vikram, Joanna, Alexandre, Marta, and Brazil is always here with open arms for you to address these interesting subjects. So thank you very much, and the attendees also.